number 28, People v. Perdue. Thanks.
Good afternoon, Your Honors. May it please the Court, Carolyn Walther for Thomas Perdue. I'd like to reserve 2 minutes for rebuttal, please.
You have 2 minutes.
Thank you. The first time in-court identification of Mr. Perdue was unduly suggestive and deprived him of his due process right to a fair trial. First-time in-court identifications like this one are both more suggestive to the person making the identification and more prejudicial to the defendant than out-of-court identification procedures. So a defense attorney's ability to cross-examine after one of these identification procedures has taken place in court for the first time is not a sufficient remedy.
But isn't the basis that you're arguing for the suggestiveness so obvious that that is why the courts say just bring it up on cross or bring it to the jury's attention?
Well, our contention, Your Honor, is that because it is so suggestive, the impression that this makes, first on the witness, that the witness is asked to pick out the person who is seated at the defense table next to their attorney. And the impression on the jury is also incredibly powerful of these
So
types
what
of
should have happened
identifications.
before the attorney was put in the position where the court says, oh, just deal with it on cross-exam?
What should have happened here really has two components. The first is notice, and the second is the ability to seek remedial measures to mitigate the undue suggestiveness.
Okay, but notice pursuant to what? Not 71030, and not our case law, and not the Supreme Court's case law, where it says that if there's a police-arranged identification, even if it is suggestive, we still have the opportunity for an independent source for that identification, right? The courts, our legislation, our legislative history basically says if there's an independent source for it, it can go to a jury. The crux of it is the reliability of that eyewitness in the identification. That can be tested still. In a setting where there's a judge, a defense attorney, a jury, cross-examination.
I would agree with Your Honor that reliability is certainly the crux of the issue here. And in this case, for example, an independent source, that might have been something that a prosecutor could have presented in a situation where there was an independent source. There wasn't one here.
But there wasn't an
critically-
identification yet. So aren't we putting the cart before the horse? There hasn't been an identification. There has been no suggestibility. There hasn't been an ID. So I'm not sure what you're asking for.
Well, I think the notice that we're asking for is notice that the witness will be asked to make that identification, because at that point, the defense attorney then has a meaningful opportunity to ask for additional measures such as an in-court lineup type procedure, evidence of an independent source, for example, that at the point at which the defense attorney learned in this case that question would be asked to the witness, it was too late. The witness had
But you don't
already
get an
been-
independent source because you can't ask the question. The independent source comes only after there's been a suggestive identification.
I would submit that if the prosecutor is required to give notice of their intent to ask, that the witness is going to make an in-court identification at that point, given a situation like this where there was no out-of-court identification procedure, the defense attorney then has the opportunity to ask for either measures to mitigate the undue suggestiveness of this type of situation, or if those aren't necessary because, for example, there is an independent source, then that's another possibility altogether.
But if the prosecutor doesn't know if there's going to be an ID made, so now you're saying that maybe they have a photo array in the middle of trial, which then is outside the 15 days that 71030 requires for notice. So now we're asking for a legislative change regarding, you know, the ID notice.
Well, not necessarily, Your Honor. So to be clear, we're not contending that this issue falls under the umbrella of 71030. This is a separate issue. An in-court identification is not covered
Are
under
you
the plain
essentially
language of
arguing
71030.
that if the witness is allowed for the first time to point to the person who traditionally sits next to the defense attorney, that's the person, that's going to taint that process? If before they sit down, they don't know if they can or cannot identify, but if they're sitting in the traditional seat, are you suggesting that's where the taint is happening?
I think that's fair to say, and that goes to the suggestiveness, the inherent suggestiveness of this type of procedure. The defendant here, there's nothing unfortunately in this record about his appearance vis-à-vis other people in the courtroom, but certainly he is the only person seated at the defense table next to the defense attorney.
Can I ask you, if that sort of inquiry had taken place, if there was a notice of intent to have an identification, what sort of mitigating, I think you mentioned defense could take mitigating steps, short of an effective cross-examination, which is obviously permitted under those circumstances, what other mitigations could have happened?
So I think this has been dealt with in the Second Circuit, in Archibald and other cases. For example, an in-court lineup type procedure where, I believe in that case, it was requested that the defendant be seated in the audience and that other individuals who shared similar physical characteristics also be included in the audience to see if the witness could pick out the defendant from among that group.
So a different identification procedure?
Different identification
What
procedure.
if there's no indication they can identify this person, as I think there was here in the reports, but hypothetical, witness comes in, and there's no intention on the part of the prosecutor to have them ID the witness, but they see the person, right? And they're like, oh, that person. What happens there?
I think in a situation where it's sort of a spontaneous statement on the part of the witness, I think there would potentially need to be some sort of inquiry on the part of the trial court in terms of whether there was some suggestiveness there. But that's not what we're talking about, and the
No,
difference here
I understand
is...
it's not this case, but what would the rule be then that allows for that gives you some type of notice here?
I think the notice requirement really attaches to the prosecutor's intent to ask the question. So spontaneous statement by a witness, I'm imagining a defense attorney might object to that, and there would be some sort of inquiry by the court. But what I'm talking about is...
Is there an intent on this record to ask the question? I just don't remember, honestly. I know there's some colloquy. I don't know if they're going to make an ID, but is it clear they were intending to ask the question?
I'm not sure whether there was a definitive statement on the part of the prosecutor that they intended to ask a question. I know that they said they did not know whether the witness would actually make the ID.
Yeah, I remember that. But then where
but I
would
think
this
it's-
fall on your line of if it's spontaneous, it's okay?
Well, the witness was asked.
They were
Do you
asked.
see that person in the courtroom? Can you
So-
point them out? And it was at that point that
So
defense counsel objected.
it would depend on the questioning of the prosecutor.
I think that's fair to say. That would be a very
Isn't the point
fact-specific-
of saying, I don't know what the answer is going to be, that there's a question to be asked?
I'm sorry, I don't think I heard
Isn't
your
the
Honor's question.
point of the prosecutor's statement that they're not sure what the answer is going to be because the question's going to be asked, because they're already intending to ask such a
Yes.
question?
Yes,
No?
I do. I think that's fair to
I
say.
thought that's what the record said.
Or it could be,
Okay.
I don't know if they're going to look over at that defense table and say, hey, I see the guy. But I think you're right. I mean, here they asked, right?
Yes, the question was asked.
I sort of assume that an implication of the rule you're asking for is that there be, the notice rule, is that there be a burden on the prosecutor before trial to talk to the prosecution witnesses and say, can you make an identification? And,
I'm sorry, I couldn't hear the question. The band.
yeah, I know.
Got a little horn outside.
I took the SATs under this kind of, I'm good at tuning it out, but, sorry, the question is, I assume that the implication of your rule is that you would want the people to ask their witnesses ahead of time to determine whether they can or would make an identification.
I-
So that would get reported, and that doesn't, that doesn't eliminate Judge Garcia's hypothetical, which is, what if they ask and the person says no, and the prosecutor doesn't ask a question like that, and the witness all of a sudden says, that's the guy. You have to deal with those as one-offs.
Right, that would be unpredictable, but dealt with in the course of trial, I think. But yes, I would agree with Your Honor. That does contemplate the prosecution asking that question to the witness.
But in this case, you did have notice that the witness could probably make an identification, because months earlier, from the body cam footage, when she was talking to the police officer, she said, yeah, I got a good look, and I could ID him again.
She did say that, and I do think it's fair to say defense counsel was aware of this person's existence. But the critical factor here is she didn't know that he would be asked to identify Mr. Perdue, and in fact, identify Mr. Perdue in court for the first time. This isn't a situation where there had been an out-of-court identification procedure, 7-1030 notice, and so she would be on notice that this is likely going to be the substance of the testimony.
So I guess I'm just struggling with, you're asking for more ID procedures that occur outside the presence of a judge with a defense attorney. You're asking for show-ups that you then have to test the reliability of. You're asking for an additional lineup, additional identifications before the one that goes on in court, where you can't be assured what happens, instead of it playing out in court. And you can make the arguments, well, look, this is the only person in the courtroom. Obviously, everyone watches TV. That's where she's going to go to make the ID. Like, I don't know why. I guess I'm struggling with why that's not effective and why that's violative of due process when you're in a court of law doing that, and instead you'd rather that take place at a police precinct without those protections.
I think, addressing Your Honor's question about due process, I would say the suggestiveness, as we've been talking about, of that type of identification, right? Everyone watches TV, everyone knows where the defendant sits. That's a piece of it, and that is in line with the cases from this court, holding that an unduly suggestive identification procedure has to be precluded. Things like a first-time in-court photo show up.
Yeah,
those are not
arranged by
allowed.
the police.
This is even more suggestive than that, I would submit. And the second piece of
Assuming
it...
that this is improper, was it incumbent upon the defense to then, when they're told that this witness could possibly, they're not sure, but may identify or be asked to identify, was it incumbent upon the defense at that point to ask for some sort of proceeding in the absence of the jury procedure to take place to test it?
I think that...
Whose burden?
I would say in the first instance, it's the prosecution's burden to disclose that. In this case, the defense only learned of the intention to ask that question after the witness had been on the stand and testifying for a number of minutes and observing Mr. Perdue seated at the defense counsel table. And so at that point, it was too late, I would submit. Any of those measures would have been essentially useless because the suggestiveness had already taken place.
So he couldn't have asked that the jury be excused when he knows this witness is coming on the stand?
I think had it happened prior to the witness taking the stand, I think that would have been perfectly fine. What happened in this case, though, it was in the middle of testimony.
Counsel, there
essentially.
was some impeachment of the police's identification procedure, right? That was questioned during, I think, a very effective cross-examination about how the police came to the conclusion that the defendant was the person who did the shooting. Isn't that true?
Well, there was no out-of-court identification procedure with this witness. Is the
I'm
court
talking
referring
about
to
the police investigator who testified, and this is really going to be my question. Which happened first? Did the police identify or claim to have testify as to how they identified the defendant, or was it Mrs. Hill? Was that her name?
Yes, Ms. Hill.
Yeah.
Which testimony happened first? That's the court's
Yeah,
question?
because what it's going to, I'll just tell you, is I'm just wondering if in the air of the trial, in the midst of the proceeding, whether the issue of Hill's identification came up because there was an ongoing dispute about whether the police method of identifying the defendant was somehow deficient as a result of the cross-examination that had taken place. And that's why the prosecutor may not have known whether Ms. Hill was going to identify him or not, but decided to ask the question.
That was not my impression of the record as the trial unfolded. And Ms. Hill did testify. She met with the prosecutor that day and the day prior about her testimony. So I didn't get the sense that this was sort of a spontaneous decision to call this witness to the stand. I got the impression it sort of fit in with the prosecution's overall theory of the case. I believe that my recollection of the record was that, I'll retract that statement because I'll take a moment and verify it.
Your time's
but
up anyway.
I see that my time is
We'll
up.
save it for later.
Thank you.
Thank you. Doesn't really help with the marching band
With the
playing in the
music,
background.
Well, I thought I'd be used to it after a few minutes, but good afternoon. May it please the court, my name is Kaylin Porter, appearing on behalf of the people. Where there has been no improper and unduly suggestive pretrial procedure arranged by...
But are you arguing that a witness coming into the courtroom, not having identified no procedure having taken place, that it's not suggestive if they're sitting at the normal place that the defendant, that they're asked the question, can you identify him? That's him, because he's sitting there.
Well, the defendant's making a due process claim, and due process has never turned on inherent suggestiveness of any procedure or...
But is it suggestive for the identification to take place when they're sitting there? Nobody else.
Justice Ginsburg wrote the Perry majority by the Supreme Court and did recognize that there is a degree of inherent suggestiveness in any identification procedure, whether that's happening before court, whether that's happening in court. Certainly, if we're assuming that a witness walking in who has been sequestered is so imminently familiar with a courtroom as to where the defendant's going to be seated, sure, there's some degree of suggestiveness there. But the benefit, though, is that it's all happening before the jury. The trial counsel can make objections, trial counsel can cross-examination, or can cross that witness as to the degree of suggestiveness there, that there's only one person in this courtroom.
So that's all assuming in a perfect world, everything is happening the way that it's supposed to. The jury's going to know, well, maybe it is, maybe it isn't. They're not going to think in the immature of a courtroom sitting on the stand and the judge is here and the person identifies in front of the judge. Might they not think, well, she or he must be right?
That determination has always fallen within the province of the jury, the reliability of a witness's testimony and whether there's any degree of suggestiveness there. A jury is determining whether a witness's testimony is truthful, whether a witness's testimony is accurate based on their observations, and they're charged accordingly.
So this first-time ID is nothing special from normal witness testimony where you just test their credibility, is what you're suggesting?
No, it does not fall under the due process clause. This is trial evidence. This is trial evidence that the jury can evaluate and determine whether or not they think that this witness is telling the truth, whether this witness is accurate, and the degree of suggestivity that is inherent in a courtroom setting is subject to cross-examination, is subject to arguments that counsel can make before the jury in summation, as well as other trial safeguards, such as the presumption of...
Do you think that the normal pretrial identification procedures help improve the reliability of eyewitness identifications?
No, Your Honor. I think that the issue with a pretrial identification, we've always looked to whether or not those affected the ultimate in-court identification and the risks that come with a pretrial identification, as to whether or not the witness then, if they're improperly suggested to pick a particular witness, then when they testify at trial, they're recalling the image of the person that the police presented to them rather than their memory.
You're answering a little bit different question than I think I asked, which is not whether an unduly suggestive pretrial procedure improves the in-court identification, but rather whether having a properly constructed pretrial identification procedure gives us more confidence in the reliability of the in-court identification.
Under those circumstances, if the witness were to identify the defendant in court, if there has been a pretrial procedure conducted, they're not testifying to the pretrial procedure. So the
Understand that.
jury doesn't hear that evidence. So the jury's not hearing about any of that type of reliability. So the jury, their reliability determination is just based on the in-court identification. It's whether or not the prosecutor is allowed to ask the question, even given the fact that there has been a pretrial procedure. Here, there has been no pretrial procedure, so the prosecutor is allowed to ask the question. We don't know
You
how...
can use a pretrial to rebut, can you here? Like if there's a charge of recent fabrication and an in-court ID, you can put in the photo spread, let's say, right?
You can. Or if the witness, on present
So it's
recollection, doesn't...
bolstering the prosecution's in-court ID in that case, right?
Only under statutorily enumerated
circumstances, right.
circumstances, right.
But let me ask this, if you have a witness and you're not sure they can make an ID, so you don't ask them, and you don't give them a photo spread or a lineup, but you call them, and then you ask them in court, okay, do you see the person who, whatever. Is that okay?
Yes, the prosecutor's taking a risk, of course, because the witness could say, look around the room and say, I don't see them here. It's a risk that is borne on the prosecutor as to whether or not they want to ask that question. The witness could say, the person isn't there, the witness could identify the
And
defendant.
the impact on the defense, are you suggesting is nothing by the prosecutors for the first time, just saying pick them?
The fact that the prosecutor could be expected to ask that question here is reasonably known to the defense ahead of time. I don't think that it negatively impacts the defense, the fact that they haven't received, as counsel requested, explicit notice. Counsel mentioned that this does not fall under the ambit of 71030, so
So would it be the defense responsibility to ask the court for an opportunity for the defendant to sit elsewhere or for some other proceeding to take place outside the presence of the jury? Would it be on them?
It would be, Judge Troutman. Any in-court accommodations, defense can, of course, ask for those. Any of those requests can be made ahead of time. Those accommodations were referenced by this court's decision in Brown, which cited the Archibald case that counsel mentioned a few moments ago. And there, the defendant did make those types of requests. The court denied the request, and then this court reviewed that for an abuse of discretion. It's not a due process claim. That is a court's discretion as to whether or not the defendant has made such a showing that those are necessary. But it does always fall on the defendant to make those requests ahead of
But
time.
how are you going to make the request when you don't have advance notice? That is to say that the damage has been done to the extent that the witness is on the stand and sees the defendant at the defense table.
Judge Rivera, I think there is every reason to believe that defense counsel should have been aware that this question could be asked.
But let's forget the camcorder for one moment. What about a case where you don't have the camcorder? What would have been the recourse for defense counsel? What could you have asked for? Other than, no, you don't get to ask the question, right? Other than to ask the judge to prohibit the prosecutor from asking the question, what other recourse would they have?
Is this a witness that was known to the defendant, or?
They may know about the witness, but there's not, like in this case, which I thought was your argument, they're on notice because they've got the camcorder, and she says on the camcorder, I can ID the person.
I think it's a fair assumption that any eyewitness that the defense knows about could be asked to describe the perpetrator. They could be asked to describe the perpetrator, to give a description of who they saw, and then if they...
You mean if there's nothing you mean just because a witness happens to be at the scene without knowing anything about what the witness actually observed, that they may be testifying to something else about the events? You should assume that they are going to be able to be the eyewitness as to the perpetrator?
I think it's fair for a defense counsel to be aware that that question could be asked. Then certainly the witness here was an eyewitness, was on the phone with 911 while she was observing the shooting.
What triggers that responsibility on the part of the defense counsel? Is it the fact that Ms. Hill said, I can identify the witness if asked to do so, or is it something else?
I think even without that, defense counsel would be reasonably aware. They know of an eyewitness to a crime, and that eyewitness provided a description of the perpetrator. I think it's fair that then in a trial, when that witness is asked to give
Well, that does suggest that you observed them, right? That the witness, I was asking about how would one know that any particular witness is going to identify the defendant? And I thought, yeah, I may have misunderstood you. I thought you were responding that as long as you know they're going to be a witness for the prosecution, related, not to forensics, right, related to the events that have unfolded, that defense counsel should assume that the question might have been asked and take efforts, appropriate efforts to protect their client under the circumstances.
If they reasonably know that this person was an eyewitness to the crime, not simply any fact witness testifying for the prosecution,
Okay,
but
so
if they...
let me then ask you a different question. Maybe you've already answered it, I just want to be clear. What, from your perspective, is the difference between the suggestiveness in a pretrial proceeding and, or pretrial identification, and the suggestiveness that we're referring to here?
Here it's all in court, it plays out in front of the jury, but the most significant difference is that it was a pretrial procedure. So the risks that are attendant in a pretrial procedure are the risk of misidentification, and that what I was describing.
But aren't a significant amount of those risks about the suggestiveness is that there's some action or some way that the procedure is established that is going to suggest to the witness who they should pick out, which is exactly the suggestiveness you're talking about in an ID, an in-court ID, where they're going to look over at the defense table and say, yeah, there's the person, not the lawyer, the person next to them.
Well, the risks of a pretrial procedure are the risk of mistaken identification, that the witness, based on improper police conduct, will choose essentially the wrong person, and they'll remember the face of the wrong person that they were presented to pretrial when they testify in court. The inherent suggestiveness of the courtroom setting
I see.
is a matter of credibility for the jury to determine
So,
they are
But
charged.
I'm sorry, but I get your point there. It's not one that's not well taken. But isn't the point that we want to avoid, given the data we now know of these wrong eyewitness IDs, whether they're because an officer or a prosecutor may have before the trial perhaps done something that suggests a particular identification versus sitting on the witness stand and there's the defendant, and so I'm going to say it's them. I'm not committing perjury, but genuinely believing that this is the person that they've seen before, that they are going to ID as the perpetrator.
Both
Aren't we concerned with the same thing, I guess, is what I'm asking at the end of the day? An incorrect ID that may result in a wrongful conviction.
No, Judge Rivera. So I would point to this court's decision in People v. Marshall, which I believe was your opinion as well in Marshall. And the risks inherent with the pretrial procedure are very different from the in-court ID. But the suggestiveness of an in-court ID, the jury is charged on that. The jury is charged that it is up to them to determine credibility, whether the witness testified truthfully and accurately. And there is a charge in there, in the credibility charge, which was read to the jury in this case, that any degree of suggestiveness is also a matter for them to determine. Now,
Don't the people do that at their peril if they're waiting until trial to ask for identification? Because at summation, during cross-examination, they will be confronted with the fact that, of course, the identification was made. So it's not like there's an advantage there. Would you agree with me there?
there's really not, Judge Singas. So as I was saying, the people did take a risk in asking this for the first time in court of this particular witness. Now, I will mention, because it was mentioned earlier, we weren't sure that this witness was cooperative. So it wasn't until the day before trial that the people had a chance to speak with this witness. It seems that she was fearful and wasn't going to testify.
And are your notice requirements based solely on police-arranged identifications?
They are. They are. This court has interpreted 71030 pretty strictly. Anything that falls outside of police arranged, where the witness positively identified the defendant, this was a pretrial procedure. If those conditions are not met, 71030 does not apply, and this court has
And in
repeatedly
this
revisited
particular
that.
instance, this witness's identification became important because the alleged victim gave conflicting identifications, correct?
Well, I do dispute the conflicting a little bit. I know that
Said it was a woman?
It seems to be a little bit of a game of telephone in the medical records. He does state at one point that he was shot after throwing a drink on a girl, which was consistent with his testimony at trial, that he threw this drink on this woman and then later was shot. That seems to be passed along through the medical records until we get to the point where it says that he was shot by the girl after throwing a drink on her. He refuted that, and he did identify the victim, or he did identify the defendant in the
But it
pretrial.
certainly helped that you had another witness, disinterested, who then came in and said, that's the person.
It certainly did, but I will also note that any first-time in-court identification will always be corroborative of other evidence of identification. The people had other evidence of identification, which did include the victim's testimony and the victim's identity.
You're saying that's always the case?
It would
So even
always,
if the people proceed with a purely circumstantial case? And
the
this would be the
circumstantial-
sole eyewitness?
it does not, it's not necessarily always the people can proceed on circumstantial evidence of identification, but the first-time in-court identification would never be the sole evidence of identification. The people could certainly proceed on circumstantial, but I will note that it will, in this instance, always be corroborative. It does not fall under the due process
But it would be the
clause.
direct evidence?
Correct.
It would be someone saying, this is who I saw?
Correct, absolutely.
Thank you, counsel.
Thank you.
All right, Ms. Walder, the music seems to have stopped, so let's get your rebuttal.
For now, let's hope.
Yeah.
Thank you, Your Honors.
What do you say about the fact that the people have said that pretrial identifications are the ones that are fraught with possible suggestiveness, that an identification done in the courtroom with the judge presiding, proper instructions, is actually a safer procedure?
What I would say, Your Honor, is I think the fact that this first-time identification is taking place in the courtroom actually cuts the other way, because it's happening in front of the fact finder. And so it's taking the issue out of just the realm of admissibility and directly implicating guilt or innocence.
As I understand suggestiveness and the challenges made, the challenge to me seems to be the pretrial ID was so suggestive, it taints the in-court ID, right? That's the analysis we do, right? And is there a way you can allow the in-court ID to go forward, sometimes despite a suggestive pretrial identification procedure because of an independent basis, whatever? Which seems to indicate that there's a presumption an in-court ID is okay unless there has been something that happens to taint it before trial. And this kind of just stands that on its head, right?
I think that's fair to say. I think, Your Honor, what we are asking for, given what sort of the body of knowledge has revealed about eyewitness identifications, this court recognized that in Boone, and said that recent information demands a new approach, essentially. And that is what we are asking for, that because
How far would
these-
you ask us to go?
What we are asking for, Your Honor, is a holding from this court that first-time in-court identifications need to be noticed by the prosecution, that the defense
How
attorney
could they be
needs a meaningful...
noticed? They hadn't happened yet. I mean, that's
No.
fundamentally my issue here. Like, nothing
underst-
is, there hasn't been an ID, so what are we noticing?
That the intent to ask the question, Your Honor, is what I believe the defense needs notice of, to give them a
Do you think that's a
meaningful...
workable rule?
I do, Your Honor, and this is along the lines of other types of pretrial rulings that courts routinely make
what would that
in
notice-
context of...
What would that notice trigger? Would it trigger some sort of inquiry by the court, or does it automatic, just to sort of understand your rule now, does it require some sort of Perdue hearing where we have to do an identification procedure before the witness is allowed to testify?
Well, I think then the next step would be that the defense attorney could request a procedure like that. It would be, I think, incumbent upon the defense attorney to make that request, and then the court could hear information from the prosecution about potentially an independent source for the identification, or what type of identification procedure that the defense attorney is asking for. But if in a case
So
like...
if they don't ask, would they've been put on notice? Then the witness gets called, prosecution can decide, again, till the very last minute, whether or not to ask the question. Maybe they choose not to, based on what the witness testifies to.
I think that would be consistent with what the Second Circuit has said on that issue, that if the defense attorney has notice and they don't make the request, that they may essentially waive.
And,
that
and I'm sorry, you were going through the procedures. Are you suggesting that there would be procedures that don't include a well, you've already started the trial, a pre-in-court identification?
Pre-testimony, I think that's possible. I think if the prosecution makes a showing that perhaps identity is not really at issue in this case,
Would that
or-
mean that the defendant has got to subject themselves at that point to perhaps a lineup?
Potentially a lineup, potentially either would be a
Photo
photo
array.
array, something along those
Yeah.
lines. But there might be a showing on the part of the prosecution that those things aren't necessary. I certainly think that's possible.
Thank you.
Thank you.